Okay, guys, welcome back to another episode of Lawyered Up. I am your host, Jared Moore. In tonight's program, we're going to be talking about the lawsuit between the Mvskoke Creek Nation and Hickory Ground and the Poarch Band of Creek Indians. My special guest tonight is Miss Mary Kathryn Nagle, and she is not only a Cherokee playwright, but she's also an excellent lawyer, and she is representing the Mvskoke Creek Nation and the Hickory Ground in that lawsuit, so she's going to have some inside baseball for us tonight. And she's joined by, is this your daughter?
Yes, this is Anna Gitchka, or Anna for short.
Awesome. So we're going to have multiple generations here, guys. So to start off with, I want to do a breakdown of the history of the case for you guys so you have idea what it's about and everything, and then we'll go into questions. If you have any questions while I'm doing that, go ahead and pop them in the chat, and we'll try to get to them in the second half. So to start off with, though, let me get in here, and we will start with, so this case is currently on appeal, and it's going to be heard, it's on the schedule to be heard right now in September of this year in the 11th Circuit. And the appeal is for a district court in the Middle District of Alabama, Northern Division of the lawsuit. So why is there a lawsuit? What's going on? So I'm going to pop up on the screen for you guys the decision or the opinion from that Middle District of Alabama, Northern Division judge in this case, because this opinion has a statement of the facts that really outlines what happened, the factual background, and we can kind of go through it in a timeline that way. There are some little tidbits that I'm going to add that aren't in this factual background, but they're more just kind of asides. So let's start off. So the factual background starts off by saying the court at this stage must accept as true the factual allegations of the second amended complaint. Those allegations, Hickory Ground is a site of long-standing cultural, religious, and political importance for the Mvskoke Creek Nation, believed to date back to the nation's original tribal town at the time of the beginnings. So what they're talking about here is there is some land that the Poarch Band of Creek Indians got that is, or the original site of the Hickory Ground ceremonial grounds. So let's go on down here. I'm going to skip over some stuff. This is the start of the story. The PBCI acquired Hickory Ground in 1980 with funding from a federal preservation grant, subject to a 20-year protective covenant requiring preservation of the property. So they got a grant from the federal government that they could purchase this property as long as they didn't develop it or do anything to it for 20 years. Now, in this factual background, the next bullet point here is in 1984. Now, there is something I wanted to insert in there. Let me pop myself back up real quick. So one of the stories that I had heard, and we've been covering this for a long time here at Mvskoke Media, but one of the things that I had heard when I started this was that in this time period, people from the Poarch Band had come to the Creek Nation and made guarantees to individuals on the council and Principal Chief Claude Cox that they wouldn't disturb this site if the Creek Nation gave them a recommendation or a letter so they could get federal recognition. Now, I haven't ever found any evidence that that part of the story happened other than what I'm going to show you, which is, and these documents that I'm showing you guys, there's a link to a folder or in the description of this video. You can click it and follow along here. The only things that aren't in that folder are going to be the stuff I'm going to show you from the Supreme Court's website and stuff like that that you guys can get access to. So if we look at the recommendation and summary of evidence for proposed finding for federal acknowledgement of the Poarch Band of Creeks of Alabama, what this is the recommendation that they be federally recognized that was filed with the Bureau of Indian Affairs. I'm going to jump ahead on this document. Oh, let me pop it up for you. Sorry, guys. I'm going to jump ahead on this document to page 117 because that's where the goody stuff is. And at 117, we go down here, and one of the things that's listed under unpublished materials is this Cox Claude A. 1983, and it says a letter from Principal Chief Mvskoke Creek Nation to John Fritz, Deputy Assistant Secretary Indian Affairs, and then it lists ordinances NCA 83-31 and -32. Okay, so from that we can see that there was a letter that was sent to the BIA by Chief Cox in 1983 that recommended that they be federally recognized and told them that in the eyes of the Creek Nation they're a separate tribe. And it also lists these NCAs. So let's see if we can go find those NCAs really quickly before we go back to our timeline. So we need to go to the Creek Nation Supreme Court website. We're going to go to the code, and I've already found it, so that's going to be easy. If we look at Title 25 here, Intergovernment and Intertribal Relations, and click on that. Let me zoom in a little bit. We can see here that Title 25 starts out with recognition here, 1-201. The Mvskoke Creek Nation hereby recognizes the Poarch Band of Creek Indians as a distinct and separate band of Mvskoke Creek Indians, and the annotation there is NCA 83-32, approved August 5th, 1983. Okay, so that's evidence that that happened. Now, I don't know, I haven't proven or shown that they sent representatives or made promises to the Creek Nation, but it does vouch up with what I was told off the record by various people that knew about what happened then. So it is interesting that that is included, that basically the tribe kind of vouched for them at that point. Then in 1984, they got tribal recognition. I'm going to skip back to our opinion here. In 1984, the Interior Department took the land into trust for PBCI following the recognition of PBCI's tribal status by the United States government earlier that year. So just to recap really quickly, the Poarch Band of Creek Indians gets a federal grant to get the land, and that land is the location of the original Hickory Ground. They can't do anything to it for 20 years. They come to, the Creek Nation passes NCAs that recognize them as a separate tribe. Chief Cox sends a letter to the BIA. The BIA gives them federal recognition in 1984. Okay, you guys following along with me? Let's move on to the next thing that happens. Now this particular one, I got to jump back to the code here, or I'm sorry, Title 25. You see here, there is I'm going to skip down here. There is a point in 1992 where the Creek Nation severs their relationship with the Poarch Band. I'm trying to find where that NCA is here. Maybe it's down here. Just 1 second, guys. Now, it says that there were some things that were done but I don't know for sure what those actions were that the Poarch Band took at that time. But let me see here. Did I get a notification? No. Uh-oh. Sorry, guys. Admit. Sorry. Okay. Back to what I was doing. Miss Nagle dropped out for a second, but we're just going to keep on cruising along here. So in 1992, the Creek Nation passed some NCAs that severed their relationship with the Poarch Band over something that happened with this property but I wasn't able, it's not listed in the NCA what specifically happened, but and I also went through the paper to try to find a story that was done about anything that happened there, and I couldn't find anything in Mvskoke Nation News. So that's a little mystery of what happened in 1992, but we're still looking into this. Moving on, the next thing that happened is, let me pop this up. Shortly after the protective covenant expired in July 2000, PBCI began excavating the site alongside archaeologists from Auburn University to gather information about the cultural artifacts buried at Hickory Ground prior to development of the area. The excavation was completed in 2011. In the meantime, the Alabama Historical Commission and others began in 2001 to write letters to the Interior Department and the Bureau of Indian Affairs, raising concerns about potential disturbance of the cultural artifacts at Hickory Ground in the course of PBCI's excavation. The city of Wetumpka, the Alabama Preservation Alliance, and an individual member of the Mvskoke Creek Nation filed suit against PBCI in 2001, making many of the same allegations reiterated in the present suit, including that the then planned excavation and clearing of the site would violate NAGPRA, ARPA, and NHPA, the National Historic Preservation Act. So this suit, this is the important part on this particular action that was filed. The suit was dismissed with prejudice shortly thereafter by request of the plaintiffs. So what does that mean? So that means that the guys who brought the suit, right, the city of Wetumpka and the Alabama, let's see here, the Alabama Preservation Alliance, those guys made a motion to drop the suit with prejudice, which means it can't be brought again. Now that is a mystery as to why they did that. I went and pulled those documents. This is in the folder. This is the complaint that they filed, where it lists various violations of NAGPRA, etc. And then this is the dismissal from the judge, and it just says, pursuant to Rule 41A of the Federal Rules of Civil Procedure, the plaintiffs hereby give notice that the above style action is dismissed with prejudice. So Rule 41A is just the rule that says that you can, as the plaintiff, the person who brought the suit, you can make a motion to have it dismissed with prejudice. So you're basically, in the same year, they brought the suit saying these guys are violating NAGPRA. Before there's a decision in the case, they make a motion to say, no, we forget it, drop the case. We don't want to bring it again. So that's weird. I don't know why that happened, and it's not detailed in the documents. Okay. Let's go back to our timeline here. So that's 2001 when that happened. According to the operative, okay, let's see, where am I at? Yes. According to the operative complaint in this case, the plaintiffs here were first notified of the excavation sometime in 2006. So that's saying that the Creek Nation was notified of these excavations of remains and artifacts from Hickory Ground in 2006. It says the plaintiffs then engaged in a years-long effort to persuade PBCI not to excavate and desecrate the remains of plaintiffs' ancestors and other cultural items, and to return any cultural items already excavated from Hickory Ground to their original resting place. So that's Creek Nation is trying to get the Poarch Band to stop digging up our ancestors and the other things, which they say which they didn't have. They'll do. Let's go on down the story. The plaintiffs also contacted National Park Service about their concerns. Negotiations between the plaintiffs and PBCI ultimately failed in 2011. The following year, PBCI reinterred many of the cultural artifacts removed from Hickory Ground at other locations. PBCI notified plaintiffs Mvskoke Creek Nation and Miko Thompson, that's Miko George Thompson, of the planned reburials by letter on April 4th, 2012, but completed the reburials before the plaintiffs responded 9 days later. So they sent out a letter telling everybody they were going to do these reburials, and before while the letter is probably in the mail, they went ahead and did it. So there was not any way for anybody to even give them any input, really. In July 2012, PBCI announced plans to develop what is now the Wind Creek Wetumpka. The plaintiffs filed the present suit that December. Construction was completed on the Wind Creek Wetumpka in 2014 during the pendency of this litigation, and the casino and resort have been operational since then. In March 2020, as noted above, the plaintiffs have filed the operative Second Amendment complaint after the case had been stayed pending unsuccessful settlement negotiations. Okay, so I'm going to try to compress all that down. PBCI bought the land where Hickory Ground is. They got federal recognition. They had a 20-year span where they weren't allowed from their grant to develop the property. As soon as the 20 years is up, they start developing it and digging up the remains and digging up the cultural artifacts. Then while that's happening, other people are complaining, but for some reason these other groups drop their lawsuit. Then the nation gets informed. The nation negotiates with them to try to get them to stop. They don't stop. They get the casino built. Then before that, in 2006, they supposedly put these artifacts in a different location. They reburied them in a different location. Casino is built. Now we're into the lawsuit period. So what happened in this case, right? And by the way, this is just, it's something, if you haven't heard of it, it's just an atrocity. It's one of the things when I started at the Nation, I started covering this, and I was like, I just couldn't believe that this happened. So, but I'm going to try to be neutral on this while we cover this court case, because it does make me angry. So, let's go down here to discussion. The court begins, let me pop that up, sorry. The court begins and ends its analysis with the tribal defendant's motion to dismiss. So the PBCI made a motion to dismiss. And what did they make a motion to dismiss with? PBCI and PCI Gaming Authority, because they enjoy sovereign immunity from unconsented suit, and the tribal officials under the doctrine announced in yada yada yada, in the absence of any tribal representatives among the defendants, the plaintiff's remaining claims cannot be adjudicated without serious prejudice to the interests of PBCI. Accordingly, pursuant to Rule 19b of the Federal Rules of Civil Procedure, the suit must be dismissed. What does it mean? The Poarch bans sovereign immunity out of the case. Right? They said we're claiming sovereign immunity, which means they can't be sued for this. They can't go into a thing. And if you haven't ever heard of sovereign immunity, tribal nations are domestic dependent nations that include among their historic sovereign authority immunity from unconsented suits absent express congressional override of immunity. So you individuals and businesses can't sue a tribe in a civil lawsuit unless Congress explicitly says so, or the tribe signs a waiver of sovereign immunity. If you look at a lot of loan agreements and things that go through the council for the tribe, many times there will be a waiver of sovereign immunity in those loan agreements for the banks so they can get their loans. Hold on, I gotta check something really quick. Okay, all right. She's back, but there's an empty room, so we're almost there. We're going to be with Ms. Nagle in a second. I assume she's taking care of the baby. So.
Yeah, I apologize.
Oh, you're fine. You're fine.
The
I'm
Wi-Fi
still
keeps going out, and I don't know why, so I keep losing the connection.
You're absolutely fine. I'm going to be with you in just a moment. There it is, Jonathan. is there doing his
Yes.
his daddy duties. So let's see, where was I? I was just wrapping up. Oh, sovereign immunity. So that's what was ultimately decided at this district court, is that the Poarch band sovereign immune out of the suit. Okay, I did want to mention one more thing, and I don't see any questions popping up in the chat, but if you guys have questions, go ahead and pop them in the chat. Okay, we're all good there. I wanted to mention one more thing before we go into the questions that I'm going to have for Ms. Nagle, is that the tribe has at least partially funded these legal actions over the years. Most recently, the council passed NCA 23076 on August 26, 2023 in the regular council session, and that bill appropriated $405,000 for ongoing legal expenses. But there's been other ones in the past, because that's how this works. So, Ms. Nagle, thank you so much for joining me. You managed to get out of the whole history thing. But my first question, while we're waiting on anybody else to ask questions, would be, so the judge decided that this is right now where we're at with this case is he's not disputing any of the facts, right? He's just saying they sovereign immuned out. In the appeal that's going to be at the 11th Circuit, how are we going to get around that? Can you talk about that?
Sure. Yeah, so the way sovereign immunity works as a doctrine, it is a bar to suit. So it's not the merits of the case. It's not about, proving the facts or your legal claims you've brought. It's just really a question for the court to answer. Can this sovereign be sued in this court? And what sovereign immunity means is usually the answer is no, unless there's some specific exceptions. We think, and we argue, and of course, I think we're right, but I am the attorney representing this case, that there are certain exceptions to the doctrine of sovereign immunity that apply in this instance. One exception that is very well known is called Ex parte Young, and that's a doctrine that says when officials, whether they're state officials or tribal officials, are actively violating federal law, then you can waive sovereign immunity to sue the officials of a sovereign in order to ask the court to issue injunctive relief to stop them from violating that federal law.
Okay.
So here, Hickory Ground and Mvskoke Creek Nation's position is that they are engaging in ongoing violations of federal law because they continue to refuse to repatriate the relatives that they unlawfully exhumed from their final resting place on these burial grounds at the sacred ceremonial site, and they continue to possess them unlawfully and refuse to repatriate them, and they're continuing to desecrate a sacred site by continuing to operate a casino on what is a sacred site, right? And a site that was placed on the National Register of Historic Places in 1980, so it does enjoy historic protections that they're continuing to violate. And so, that is the argument that we have about ongoing violations, and the district court noted that we plead ongoing violations. However, the district court also applied this very arcane doctrine that no one follows today called Coeur d'Alene, and that's a Supreme Court case where the court found an exception to the exception, so an exception to the Ex parte Young doctrine. And I think we have a lot of really great arguments about why Coeur d'Alene does not apply to this case. And so, the unfortunate situation is just that when we argue our case in September, really what we're going to be arguing are these legal doctrines. I think we have a really good shot at winning, but you never know. And at the end of the day, we won't be talking about all the horrific things that Poarch did. And that's really the story that needs to be told.
Yeah,
right? And the court won't be hearing about that. So,
yeah. And the court, it doesn't look like the judge in this case either was disputing those facts, when he was going through. So my question too is, so on the Coeur d'Alene, it seems like this is maybe, and you could correct me if I'm wrong, uncharted territory where we're dealing with one tribe suing another tribe, and then that tribe's sovereign immunity. Is that unheard of? Have we ever seen that? Like two tribes?
It's not complete. It's rare, but it's not completely unheard of. There's another similar case where the Wichita tribe decided they wanted to build a travel center and historic cultural center on top of the burials of Indian children at the site of the original Riverside Indian boarding school. And the Caddo Nation sued the Wichita tribe in federal court, saying this violates same, NAGPRA, NHPA, NEPA. I think they were also arguing there needed to be a full environmental impact statement in that case. And in this case, same issue. And actually, district court found that sovereign immunity had been waived in that case as well, and slightly different circumstances than the ones we have here, but similar in that you have one tribe suing another, arguing there's been an exception to sovereign immunity, and it's about whether or not there's these violations of federal law that protect our sacred sites and our burial grounds and our historic places.
Okay. So what's the next step? Let's say that the 11th Circuit rules in favor of the Creek Nation. Can it go up, or is that a terminal? Where do we go from there?
I mean, certainly, if we win, Poarch would have the option, as well as the federal government, because keep in mind, it's us on one side of the V, and Poarch and the federal government is on the side of the V with Poarch, as well as Auburn University. And so any one of those defendants could, depending on the outcome of the case, any one of those defendants could ask the Supreme Court to hear and reconsider the 11th Circuit's decision. I think it's unlikely that the Supreme Court would grant cert on at this stage in the game, because we haven't had a final adjudication. It's just about sovereign immunity, and I don't, but you never know. Certainly they could ask the Supreme Court to hear it. I think if we win, I would be surprised if Poarch didn't ask the Supreme Court to hear it, but you never know. It's most likely procedurally to end up going back down to the district court if we win.
Okay.
If we lose, we could ask the Supreme Court to hear the case. And if we don't, or if the Supreme Court says no, then the whole case is over. This case.
Right.
Whether or not there are other claims that we could bring to protect Hickory Ground, I think the nation would probably be interested in looking at that. But in terms of this particular litigation, it would be over if we lose and the Supreme Court doesn't hear it. If we win and the Supreme Court doesn't hear it, and we go back down to the district court, we're really starting at the very beginning here, because the sovereign immunity arguments, those are the very first arguments a tribe or a state will make to prevent itself from being sued in federal court. Mm-hmm. And we have not gotten to the merits. We have not had discovery. We have not gotten documents produced. We have not been able to take depositions of the Poarch officials who said, exhume these 57 relatives, build the casino on top of this burial ground. We want to depose those people and understand more about that decision-making process that culminated in violating federal law. Who made that decision? What were the circumstances? And I think it'll show how culpable and knowledgeable they were about violating federal law and destroying this sacred site. But certainly their story has been to the world right now, and on Capitol Hill right now, where they're asking Congress to pass legislation to sort of circumvent this lawsuit. Their story is that they had no idea this sacred site was here until they started building their casino, which is just not the truth, because as you pointed out, in their application for the federal funds they needed to buy the site, they told the federal government, hey, give us the money to buy it, because it actually is a historic site of significant cultural value to the Creek Nation, and we'll protect it for their benefit because we care about our relationship. We're Creek too, and so we want to protect this site. Obviously, that's not what they did once they got the money and the land, but so we would be going back to district court and litigating this case, and they would probably file renewed motions to dismiss. So before we get to a trial, we would have motions to dismiss, depositions, discovery, probably motions for summary judgment. So there's a lot. It's crazy because this case was filed in 2012, but this could be a really long case.
Yeah, I think so. Now, you mentioned that the federal government is on the Poarch band side of the V. What's the federal government's, what is their standpoint on this?
Well, I will say that the federal government has absolutely abdicated their federal trust duty and responsibility to the Mvskoke Creek Nation in this instance. They should never have placed this land in trust with Poarch to begin with. They did so under faulty pretenses that violate federal law, and that's certainly our claim in the lawsuit. But even worse than just putting the land in trust for for Poarch when they got reports from not just us, not just my clients, the Creek Nation and Hickory Ground or Rico Thompson, but also the Alabama Historical Society, the Alabama State Historical Preservation Officer. They were telling the Bureau of Indian Affairs, hey, this violates federal law, what they're doing over here. You also had the AHCP, which is a council that sort of advises on cultural historical preservation. It's a federal agency, a federal council. They also issued a letter to DOI saying, hey, this is violating federal law and this needs to be stopped. And they actually said, it seems like Poarch is very purposeful in they're continuing to construct on this site when we know that there are people buried here, and it needs to be stopped. It's a violation of federal law. And the National Park Service and the Bureau of Indian Affairs and the Department of the Interior did nothing to stop it. And it was absolutely their federal trust, duty, and responsibility, not just because of the treaty obligations they owe to Mvskoke Creek Nation, but also because of the plain letter of the law in the National Historic Preservation Act, as well as the Native American Graves Protection Repatriation Act. They had duties and they failed to do them. So we're suing them because of those failed duties, and those duties are ongoing. They gave some of their duties in terms of, they are sort of the guardian of some of our most protected sacred sites, right? They have the National Park Service protects sites on the National Register of Historic Places. They gave the preservation duties over to Poarch. And the only way they could do that under the NHPA, a federal statute, the only way they could give those duties to a tribe is if the tribe signs an agreement saying, we promise to protect this site. We promise to consult. If we're going to take any action that could be adverse to this site, we are going to consult with other tribes who may have religious or cultural relationships or attachment to this site. So under this agreement, they promised to consult with Mvskoke Creek Nation before doing anything at Hickory Ground, and they didn't. And under the terms of that agreement, the moment that Poarch violates that agreement, the National Park Service has a duty under federal law to terminate that agreement, and they have not terminated that agreement. And in fact, Creek Nation, just within the last year, wrote a letter to the National Park Service and to Secretary Deb Haaland saying, Poarch has clearly violated this agreement. You are now obligated under federal law to terminate the agreement with Poarch, and they have failed to do that. So the sort of federal government violations of federal law and their trust duties to Mvskoke Creek Nation are ongoing and continue to this day.
So with the situation as it is, and this is a question that I have thought about a lot over the years of this, is because, and I bring this up also because in the past 5 or 10 years, I have spoke to a lot of citizens or this contingent of citizens has grown that say, hey, we need to have this be water under the bridge, and we may need to make amends. Some of these porch band guys are coming to our grounds, et cetera, et cetera. And my question would be, what does the end of this, what does the nation want? How can this be resolved? Can it be resolved? Outside of the legal filings and everything, and because just like what you were saying, the case could end up being dismissed, and then we might have to try to figure out some other legal action or whatever. We could run out of legal actions. Is there any way to make amends? Is there a way to bury the hatchet, or should we do it? It's one of those things where it's like the more you learn about the atrocities that were happening. One of the things, and this is just for you guys in the audience, when I first started working here, there was one of the very first stories we did on the TV show at that time was a contingent of porch band coming down to the Creek Nation to try to consult with the council, and some individuals from the ceremonial grounds came out, and really, it was kind of scary for them because they were incredibly angry, as you would be at the fact that they were just going to try to pave over this whole thing and say, hey, it's okay, here's a box of cigarettes, we're all buddies, don't worry about it. So what do you think the ultimate resolution could be if there is one?
Well, it's a great question, and I will just say, ultimately, I defer to Chief Hill and Miko George Thompson on that, because my job as attorney is to just litigate the claims. Now, the complaint that we filed in this litigation calls for several resolutions to the issue, and so one is repatriate, right, under NAGPRA, protect the rights of the nation and Hickory Ground to, you know, there's there's a lot of damage that we can't undo, but certainly Auburn University and Poarch do not need to continue to hold these Mvskoke relatives in trash bags and boxes in the kind of storage bins that they have them on site at Poarch as well as at Auburn. They need to be returned and repatriated. And the only reason they're not being is because Poarch has told Auburn not to. And Auburn has taken this position of, well, we don't know what to do. We got one tribe telling us this and one tribe telling us that.
Right.
Poarch dug these relatives up, right? So at the end of the day, for them to act like they care at all about what's best or right in any kind of Mvskoke cultural understanding is just pure blasphemy. And they need to be returning these relatives to Hickory Ground, to Mvskoke Creek Nation immediately, and they're not. And so beyond that, I think that there's a lot of different ways that these issues could be resolved. I can't speak to the settlement negotiations that have taken place, because those conversations are all confidential. But yes, I think there are different ways that this issue could be resolved. And I think that, ultimately at the end of the day, what we're looking at is a group of people who claim to be Creek or Mvskoke, but don't want to follow those cultural values or understandings. And I think, again, I defer to Miko George Thompson and Chief Hill in terms of how they want to try to make amends. The parties could settle this lawsuit at any point in time, but I think, absent that kind of an agreement, Miko Thompson takes very seriously his duty to protect the relatives that were buried at Hickory Ground and what that ceremonial sacred site is and continues to mean to Hickory Ground members today. And I think that, my understanding, and again, I will defer to Miko Thompson and everyone at Hickory Ground on this, is that they're willing to fight as long or as hard as they need to do what's right by their own relatives and their cultural understandings. And so whatever it takes to continue to fight that fight, to achieve that good outcome, they're going to keep doing that.
Okay, great. So my other question too would be, well, I just lost it. So this case has been put on several tentative schedules.
Yeah.
How confident are you that it's actually going to get heard in September? Or are we looking at another delay? What do you think? I know it's impossible to tell, but
I will say I'm decently confident, just because, we've been bumped around a lot, and there's been speculation. I think most likely it is harmless. I don't think there's something corrupt going on, but it is odd that we've been bumped around as much as we have been. But this time we actually have been placed on we've been actually given a specific day that the argument will happen. It's September 25th. And every other time before, we were the week of May 16th. Then they moved us to the week of September 16th in Birmingham. And then we got moved to the week of September 23rd in Atlanta. And now they've said, actually, you are September 25th. In Atlanta. So the fact that they've actually scheduled us on a very specific date makes me feel a little bit more confident that this is a bit more finalized, and they're less likely to cancel and move us around like they've done in the past. And so I know that we are actually going to be meeting with Miko Thompson next week to talk about the plans. But I know that Hickory Ground and the nation are going to want to ask Hickory Ground members, but members of other ceremonial grounds and Mvskoke Creek Nation citizens to join the nation in Hickory Ground in Atlanta on September 25th. There will be hosting some events, and whether it'll be a vigil or a rally in support of this cause, which is to protect Hickory Ground and to do the right thing by everyone who was buried there. There will be events that we're hoping people can attend. And so if anyone's interested, please stay tuned. There will be announcements made. My guess is, I can't promise anything yet, but my hope is that There will be ways that the nation will help fund and support transportation for those who want to come out to Atlanta. But anyone who can come, we welcome you. I hope Mvskoke Media will be there to cover it. I think it's going to be a really important opportunity for Mvskoke Creek Nation and Hickory Ground to tell their story.
Well, it's definitely on our radar, and we're going to try to do it. The other thing I wanted to mention to the audience too, and it's kind of a question, is the 11th Circuit does live stream their hearings on their website. So, and I don't know if you guys will be notified of that ahead of time. I think their website says that the parties will be notified like a week ahead of time before the actual hearing or whatever. So, if that is live streamed, we're going to restream it on our channel here just so we can keep it in the record and everything, because the 11th Circuit had a YouTube channel, but I don't think they put stuff on there anymore. I think it's just on their website anyway. And then if we can get to that hearing in Atlanta for that, because I think it's going to be it's really kind of a downer sort of story, but it is something that citizens need to know about. Citizens who are watching this, and they want to find out if they can go to this event or get transportation, who should they reach out to?
This is a really great question. I don't know just yet, but I would say Jason Salzman, who's the president.
Okay, all right.
Put Jason on the spot. We will make sure that once we come up with a plan through Miko Thompson and Chief Hill that everyone's on board with, we will have, Secretary Salzman put it out through Facebook, Twitter, he's got Instagram. It's going to go out, right? And so look there. But if you have any questions, you can reach out to his office. I think it's also fine to reach out to Secretary Raylan Butler. She's certainly helping with these efforts, or to contact Hickory Ground. I don't want to send everyone. I don't want to blow up Miko Thompson's cell phone, but I think if you know someone from Hickory Ground, you can check in with them, because they'll certainly have information on the plans. Again, we just found out that the case is being argued on September 25th, less than a week ago, and we're meeting next week to finalize all the plans, and so we will be putting the word out very soon. And I just really want to encourage anyone who's thinking about coming to please come, because it will make a difference if you're there in the courtroom listening to the arguments, if you're there at the rally, at the vigil that's going to be organized. I think it'll really make a difference.
Yeah, and I also want to tack on to that too. And of course, guys, if we find anything out about this, we will let you guys know.
We'll definitely let Mvskoke Media know.
Yeah, for sure. But also, maybe if you're watching this and you're one of our viewers who's a native citizen, but you're not Mvskoke, this is like a huge issue with repatriation or reburial and NAGPRA and everything. This is like it's a horrible thing that's been done, and it happened to be done by federally recognized tribe, and it's being supported by the federal government. It's one of the biggest, I think, remains situations that's happening right now in the United States. So
yes, it really is. It really is. It absolutely is, and I think that it's one of the biggest desecrations in the history of the United States. Honestly, so it's a big deal.
Yeah. Well, thank you so much, Mary, for joining us today. And
thank you so much for having me. I really appreciate it.
I wish it was under different circumstances, but it's good that you guys are fighting this fight. It's something that's been going on for a long time. I've been covering it for a long time, and hopefully maybe we can get some type of resolution and get some justice on this deal. I want to thank you guys for tuning in today. I'm going to give you a heads up. Next week on Thursday at 6 p.m., we are going to have Mvskoke citizen Dennis Baker. He is running for Congress, and he's going to be talking about his campaign, and that's what's on the schedule for next week. That's going to be a live wire, so if you have any questions for him, tune in and pop them in the chat. I don't see any questions in the chat right now. So with that being said, Mado Hadum, and we'll see you next time. Chihichath, Lees.